the matter of Salix Home and Mantato.
My Lord, I appear on behalf of Salix Home, the appellant in this matter, with my junior, Miss Varley, and my learned friend, Mr. Stark, appears on behalf of Mr. Mantato, the respondent. Yes. My Lord, I propose in my submissions to briefly deal with the basic facts of the case.
Well, I wonder if that's necessary at this stage, anyway. We've read, obviously, the skeleton arguments, we've read the judgment carefully below. Some of us have read a bit more than that, but we've certainly got all of that. And we've had a very useful chronology as well, what's happened. I don't know the extent to which you need to go into too much of that. I'm certainly not stopping going to any of the facts. What I think we'd like to do is we'd like to hear, first of all, the submissions on both sides on the estoppel point and on abuse. When we've heard all of that, then we will deal with the question of delay. And at that point, obviously, the facts become critical. So what I think would be sensible would be, if you wish to refer to the facts at this stage, just do so far as necessary for the estoppel argument.
Certainly, my Lord. And indeed, what it might be helpful to do is just look at the court orders.
Yes.
They're in the supplementary bundle at tab 3. Right. Because as you'll appreciate, my Lord, this is a possession claim originally brought by Salford City Council because Mr. Mantato was originally a secure tenant of the property at 20 James Henry Avenue. And a rent arrears accrued, and in the normal way, the local authority sought possession under ground 1 of Schedule 2 to the Housing Act 1985. In other words, a discretionary ground based on non-payment of rent. And my Lord will see at tab 3, it starts off with the possession order made by Deputy District Judge Ayres on the 22nd of April.
Yes.
Now, I just pause to say that it's not probably in the form that you would see today, because one sees very few postponed possession orders today, because the question of tolerated trespassers, which brought in much stronger the issue of proposed postponed orders, has effectively been resolved. In other words, the tenancy clearly continues, whether an assured tenancy or a secure tenancy, until execution of the order. There was felt to be a need to have a device to retain the tenancy at the time that the order was made in 2008, which is why it's a postponed order rather than a suspended order that you'll have seen in 2017. I don't think we particularly need to go into the tolerated trespasser issue, but that's why you see it's postponed. And my Lord, what you can see is a fairly normal paragraph 1 to the order, of course. It's a possession order. But because it's postponed, there's no date given. And as I say, the intention was therefore not to have an end point which the tenancy would end. And the local authority wouldn't have been entitled to seek a date for possession unless there was a problem with the order in terms of current rent plus instalments that you'll see at paragraph 4. In other words, the claimant shall not be entitled to make an application for a date to be fixed for the giving up of possession and the termination of the tenancy, so long as the defendant pays the current rent together with instalments of £3.05 per week towards the judgment debt. And at the time, that was the normal amount provided for people on benefits, because that was the amount that you could have directly taken off your benefits from the DWP. So that's at the time, a fairly usual order. And unfortunately, Mr. Mantato didn't maintain the payments under paragraph 4, and therefore the local authority were entitled to apply for a date for possession. And that's what you see on the next page.
The order that the Deputy District Judge made distinguishes in paragraph 4 between the current rent on the one hand and £3.05 a week towards the judgment debt.
Yes.
It says just below paragraph 7 that it is adjudged that the claimant recover the sum of £14.31.66 for debt plus the costs. So the judgment debt is £1,586
That's right. It's the arrears as at the date of the order and the costs.
Current rent is not part of the judgment.
Absolutely. Current rent is purely a condition upon which, unless there's compliance, a date can be provided for possession. And in a sense, my lord, that's one of the appellant's main points. It's not part of the judgment debt. It's purely a condition in respect of enforcement. Because we see at page 31, as I say, a fairly normal order at the time because there had been a breach. And although Mr. Mantato didn't attend that hearing, all that hearing would have given a date for possession. And of course, my lord, what that would have meant is that one has an outright order. And then we see at page 32 what the result of that is. Salford City Council have their date for possession, they have their outright order, they're entitled to get a warrant of possession, they get a warrant of possession, and you can see that Mr. Mantato is perfectly entitled, because it's a discretionary ground, to make an application to suspend the execution of the warrant, and that is what he does. And in 2009, in July, the court accedes to his requests that the stay of execution be granted upon current rent plus £16.02. You'll notice there's no reference to the amount of the arrears at that point, but that is what will stop the execution. It means that at this stage, of course, we still have an outright possession order. It's just that the execution is being stayed upon those terms. And in the following pages, my lord, what one will see is a succession of warrant applications, if I can put it that way. In other words, situations brought about by continued failure to comply with the conditions by Mr. Mantato and him exercising, as he's entitled to, his right to seek a stay of execution each time the warrant is either reissued or a new warrant is issued and a new date fixed for his eviction. He's perfectly entitled to make that application. And in the county courts up and down the country, of course, it's perfectly normal for people to have 3, 4, 5, 6 bites of the cherry. One sees, for example, at page 33, the Deputy District Judge suspends the warrant of possession, again, not the order, but the warrant of possession, upon current rent plus 330. That goes up every April. And in 2012, on the next page, page 34, current rent plus £5 a week.
Just so I can get this correct. In 31,
yes,
that's the order for possession, that fixed the date for possession.
That's right.
That's not a warrant for possession.
Not a warrant for possession.
So the next page.
My lord, it's as if that page you see at page 30, which made the possession order, simply said possession order 14 days or whatever.
On 32, it says the warrant of possession be suspended. So we don't have the warrant for possession.
We don't have the warrant. Okay. There would have been an application to the court, a paper application to the court.
Yes.
Now, there obviously has been certain developments in that area in terms of whether one needs permission to get a warrant for possession in respect of rent arrears. And at one stage, of course, following Cardiff and Lee, which you've got in your bundle at tab 17, there was felt that that was always a requirement that you should get permission to issue a warrant. The present state of play is that the system has changed, and when the situation is rent arrears, one doesn't need permission to issue a warrant. What one does is one has to put a schedule in with the request for the warrant.
So what's happening is what's happening in each of those. So between 32 and 33, between 31 and 32, there's a warrant for possession has been issued. Then between 32 and 33, is there another warrant for possession, or is it the same warrant?
It's unclear whether there's another warrant. A warrant has a life of 12 months. It can be extended by the court, or a new warrant can be sought.
So what is the position? If you have a warrant for possession, which is suspended on terms, and the terms are not complied with, you can, and assuming it's within the 12 months, you can simply use the bailiffs go in under that warrant, does it? Do they?
What the warrant would do on each occasion, it will give a date for possession. Normally, particularly in London, I'm not so sure about the position in Manchester, my learned friend will know better, it would be 4 weeks, normally 4, 5, 6 weeks. Then the tenant is entitled to make their application to stay execution of that warrant. Normally by the time there's been a hearing, either that date for the eviction has passed or it's very close. If it's passed, then the landlord would need to either reissue that warrant or would need to get a new warrant.
Oh, I see.
it doesn't make much difference to the analysis, but it
I'm
obviously...
just interested. So the warrant for possession has a date in it.
Yes.
And
Well,
once
actually-
you get to that date, you've got to either get a new one or get it extended or something.
That's right. And as I say, London, in a sense, has the luxury, not deliberate, of course, because it's so busy, to having 4, 5, 6 weeks, even on forthwith possession cases. I remember doing one in Oxford not so long ago, and they gave me a date for possession with a warrant about 7 days in advance. So it depends how busy the bailiffs are and what their workload is. There's nothing fixed by the rules as to how long that should be. So these are all warrants either reissued or newly issued by the local authority because of continued failure to comply with the conditions, which are, if I can put it this way, updated each time he makes an application. And one sees, if one takes the example on page 34, where it says paragraph 2 in the order of Deputy District Judge Leyland, claimant's cost of £100 and added to arrears. That £100 relates normally to the cost of the warrant. I mean, it changes, it's not £100 now, I think it's 120 apparently. But, so that is what is happening at this stage. And that goes on, my lord, until page 36. We're still in the arena of Salford City Council being the landlord. There's no different procedure at this stage. He's made a further application because he's failed to comply with the previous stay terms. And you can see that the judge on that occasion, Deputy District Judge Griffiths, does agree to stay it, gives a warning within the preamble that he may be lucky to get another one, but that has no particular specific effect. It may just assist the future judge, but they have to exercise their discretion afresh each time. And this is the only order which actually mentions arrears in terms of amount. It just records the fact that the arrears by this stage are £2,506.45. And you'll recall there was something a little over 1,400 at the time the possession order was first made some 5 years previously. But that's no different than the previous days of execution you've got. And my lord, as far as that first possession claim is concerned, the 2008 possession order, that is it. Chronologically speaking, of course, what we have is a stock transfer, as so often, from the local authority to the housing association, Salix Homes, the appellant in this case. That means, as far as Mr. Mantato is concerned, he's no longer a secure tenant, because he can't be a secure tenant, because he doesn't satisfy, or Salix Homes don't satisfy, the landlord condition of Section 80 of the Housing Act 1985, and therefore he becomes an assured tenant. Not a great deal of difference, and certainly no difference for the purposes of this appeal, but he's an assured tenant on the same terms. What Salix Homes do is that they issue fresh proceedings because of an ongoing problem of arrears. You'll see the actual claim itself at tab 10 in the core bundle, but I don't think we need to go to it particularly, my lord, but the actual claim itself is at tab 10 of the core bundle. But it's a standard, what's called a PCOL claim, possession claims online, claim for possession in rent arrears.
You claim possession in the second action, not only on the ground of existing arrears, but also on the ground of persistent delay.
Yes. The grounds are grounds 10 and 11. Grounds 10 is arrears at the date of notice and arrears at the date of issue of proceedings, and ground 11, as you rightly say, my lord, is persistent delay in paying rent. And that obviously is particularly used where people keep clearing arrears and then getting new arrears and keep clearing arrears, but it can be used in other cases as well, of course. It's never been suggested, of course, that there weren't arrears. It's never been suggested that those grounds weren't satisfied. Of course, in 2017...
You said core bundle 10.
Oh, sorry, core bundle tab 10.
I've only got up to 9.
Sorry, my lord?
My core bundle only goes up to 9.
Ah, it's page 89 of the core bundle.
Oh, 89, sorry, then that's... oh, yes, it says 10. I haven't got a tab for 10.
I'm very sorry.
Why is that? Hang on, maybe my tabs are in the wrong place.
So that's true of all your lordships.
Hang on. Yeah, it's actually, in my one it's tab 8 for some reason. The index says tab 10.
Oh, I apologise for that.
That may be, I don't know why that is.
I suspect it was some additional pages were put in. They probably weren't put in. Properly.
Anyway, it's tab 8.
As I say, this is a fairly standard, well, it is the prescribed form for possession. You can see that N5 claim form for possession at the bottom left-hand corner. The claim form itself makes it clear at page 90 that the grounds are rent arrears.
If I've understood correctly, Mr. Lane, the first action brought by the council was only on ground 1.
On ground 1, that's right.
That is arrears of rent.
That's arrears of rent, my lord, yes.
The second action brought by Salix was both arrears of rent and persistent delay.
That's right, although that's absolutely right, my lord. But of course, in respect to the first action, in terms of rent, there was only that possibility available to the local authority.
Yeah.
But yes, it is an additional factor. And in terms of what Salix Homes would need to prove, it was different because, of course, they have to prove, as I say, arrears at particular points in time for the purposes of ground 10 or persistent delay for the purposes of ground 11.
Which wouldn't necessarily require existing arrears at all.
No, that's absolutely right. I mean, particularly for ground 11, and indeed for ground 10 if they've cleared them post-issue of proceedings. That's absolutely right, my lord. And of course, many social landlords, they have available to them ground 8, which is the mandatory ground for possession, which is
It's 3 months.
8 weeks or 2 months. It was 3 months initially, but it's now 8 weeks or 2 months, depending upon how you pay your rent, at the date of notice and at the date of hearing. But it's fair to say that many housing associations choose not to use that ground, not least because obviously guidance from the regulator and so on suggest it should be used sparingly. It is an option for them. Quickly going through the particulars of claim, you can see at page 91, again, this is the N119. This is the standard prescribed form that you're meant to use for rented residential premises. Standard details put in there, and you can see at 4A, my lord, you'll see the grounds relied on, which my lord, Justice Lewison has just referred to, grounds 10 and 11.
Yeah. Yes.
And you can see at paragraph 6, for example, there is of course a notice seeking possession, which is just a warning to somebody, as the local authority would have issued themselves. It's a warning to somebody that we are thinking of taking possession. It doesn't have any effect on the tenancy, it's just a warning. And you can see at page 93, in terms of the prayer, what is being sought is possession of the premises, unpaid rent and any charge for use and occupation up to the date the order is made, rent and any charge for use and occupation from the date of the order until the claimant recovers possession of the property and costs. My lord, this is something that always causes confusion because having already said, and I don't think it's a matter of legal dispute between the parties, that one continues as a tenant, whether secure or assured, until execution of any possession order, there is no basis for use and occupation anyway. One is always paying rent and one always continues your tenancy, and therefore one's always obliged to pay under the terms of the tenancy, whether that's weekly in advance, as here, or monthly in advance, as is the case with some tenancies. So the use and occupation prayer element is always unnecessary and doesn't really apply. And you can see at page 95 there is a short payment history given showing last payment on the 12th of March 2000.
Well, I suppose we don't need to get into that.
But my lord, that's the possession claim that led to what we see then in the supplementary bundle on page 37, which was the suspended possession order. And my lord, although we've moved statutory regimes, in other words, we started off with the 1985 Act for Salford City Council and sections 83 and 85, and we've now moved to the Housing Act 1988 and section 7 and section 9 of the Housing Act 1988. They are very similar powers, and I'll take you to them very shortly. But I just want you to first of all notice that first of all Mr. Mantato didn't attend. So this was a first possession hearing, which, of course, as you'll appreciate, my lord, is courts up and down the country, you know, have every day of the week, have a list.
This is a first possession.
But despite the fact that he's not there, and despite the fact that there was no defence filed or indication from him as to what the problem was, you can see what actually happens here is that, firstly, there is a possession order made at paragraph 1, and because we're no longer in the postponed order regime, it gives a date for possession, 7th of July 2017. But Salix Holmes want to give him an opportunity and therefore agree to a suspension. And my lord, this is a discretionary ground, and therefore the court just has to appreciate whether or not it's reasonable to make an order and whether it's appropriate to suspend such an order if made. You can also see there is a money judgment made at paragraph 3, and there is a fixed costs order. In other words, it is a fixed cost regime, whatever the actual costs of the landlord or their solicitors.
So, just because I've forgotten this from years ago, but does the court have an obligation under some statute to consider suspension?
What they have an obligation to do is that, first off, if they're satisfied, the grounds are satisfied and the notice seeking possession has been served or it shouldn't be dispensed with, what they have an obligation to do is, first of all, consider whether it's reasonable to make a possession order, because these are discretionary grounds. If they consider it's reasonable to make a possession order, they should then go on to consider whether that order should be made outright or whether it should be suspended on terms. And my lord, it may be appropriate just to have a look at tab 19 of the authorities bundle. This is the Housing Act 1988, because it's an assured tenancy regime now because it's a housing association. And, my lord, I mentioned earlier two sections of the Act. One was section 7, which you'll see at page 244. And for the purposes of this matter, it's subparagraph 4, which says that if the court is satisfied that any of the grounds in Part 2 of Schedule 2 to this Act, and that would include grounds 10 and grounds 11, if they're satisfied that's established, then subject to sections 5A and 6, which we didn't concern ourselves with here, the court may make an order for possession if it considers it reasonable to do so. So even if there are arrears, even if the grounds are satisfied, they're not obliged to make a possession order at all. But if they consider it reasonable to do so, they must do that. It's why, for example, when one sends in agreed orders, you can't have consent orders, you just have to have something in the preamble which indicates that the court finds that it's reasonable to make a possession order, because it's the court that has to decide it's reasonable. One then looks at section 9, and in particular subparagraph 2, on the making of an order for possession, so assuming that the court finds it's reasonable to make an order for possession, subparagraph 2 says, either on the making of an order for possession or at any time before execution of an order, the court, subject to subsection 6 below, which need concern us, may stay or suspend execution of the order or postpone the date of possession for such period as the court thinks just. So they're entitled, that's where they would get their powers from, to suspend the order or indeed stay execution of a warrant.
Yes, because this is standard process
Yes.
in the county court.
Yes.
In this type of case, you suspend the terms.
Yes. Well, and the reason you do that is because of subparagraph 3, my lord. You have a look at that.
Well, 3 and 4.
3 and 4, that's right.
Yes.
On any such adjournment as is referred to in subsection 1 above, or on any such stay, suspension or postponement, and obviously we're concerned with suspension in terms of the SBO, as is referred to in subsection 2 above, the court, unless it considers that to do so would cause exceptional hardship to the tenant, or would otherwise be unreasonable, shall impose conditions with regard to payment by the tenant of arrears of rent, if any, and may impose such other conditions as it thinks fit. So, for example, if I'm representing Salix Homes at a rent case, and I'm happy enough for the court to make a suspended order, clearly the court's going to want to know, well, what can the tenant afford to pay? There's no point saying £50 a week if they're sat there and saying, well, I'm on benefit and I can afford £3.50. It's got to be reasonable. It's not got to cause exceptional hardship to the defendant. Now that, of course, may mean that you don't make you make an outright order if they can't clear the arrears in a reasonable period, but it's a quid pro quo. But that's what the court has to consider. I'm also entitled to ask for other terms. So if I say, for example...
But I think we need to go...
No, but I am entitled to do that.
All right.
So that's the power that allows the court to make the order it did at page 37
Yes.
of the supplementary bundle.
Yes.
And what you've also seen, my lord, from that is that power to stay execution continues until eviction. So, my lord,
It's suspension, what is stay? It's suspended. It's suspended.
This is a suspension of the order, yes. Because in terms of the chronology, my lord,
Yes.
what then happened was that a warrant was issued because those terms weren't adhered to by Mr. Mantato as before, and that therefore a warrant was issued and an eviction took place on the 12th of September 2017. Now, he would have been entitled at any stage prior to the 12th of September 2017, and even prior to the actual time of eviction. If it was a 2 o'clock eviction, he could have gone to court in the morning, for example. He was entitled to apply for a stay of execution.
So, just a minute, I need to make a note of this. I know we've got a chronology. So, the 9th of June is the order saying you've got to give possession on or before the 7th of July.
But
Then it's suspended, he doesn't comply, and eventually on the 12th of September, possession is given.
yes,
Pursuant to this order.
that's right, my lord, yeah.
Yes.
Now, my lord, in terms of the question of the first grant and the question of merger, I think that's as far as we need to go.
Yes.
Indeed, in terms of delay, which is, as you might imagine, isn't
Well,
the
we'll come back to delay because
Yeah.
that's more
it's
complicated.
not the primary ground of the penalty, as you might imagine, in any event, but it's a question of the first ground in particular that we're concerned with.
Sorry, say that again?
Sorry, the primary ground I want to make submissions on, subject obviously to what your lordship wishes me to talk on, is the question of the first ground and the question of
quite.
merger.
Merger and abuse.
Yes.
Yeah.
So, my lord, that's, I think, as given your indication, that's as far as we need to go in terms of the factual summary. And of course, as you've indicated, you've read the judgment of Deputy District Judge Thexton and would have seen that as far as he was concerned, for various reasons, he felt it was an abusive process, and indeed he accepted the merger argument of my learned friend
Yes.
and said that what you should have done, in fact, the only thing you could have done is gone under the first order and applied to the court, A, to substitute yourself for Salford City Council, and B, to then seek permission to issue a warrant out of time, i.e. out of 6 years. And that's why he said that. My lord, what we say is that there are some, I think it's fair to say, uncontroversial facts of this case. We know that he was, and indeed I suppose technically speaking still is, a periodic tenant. It doesn't matter whether he's assured or secured, we know that. We know that he has an obligation to pay his rent. The rent schedule shows that he has a weekly obligation to pay his rent. We know he's fallen foul of that requirement, despite court orders for some considerable time, something in the region of 11 years. And we know that the grounds for possession were satisfied in both cases, albeit that my lord had indicated in terms of slightly different conditions, but they were in relation to rent arrears. We know that there was no, and has been no, public law or Equality Act defence being put forward. There's been no set-off claim that says that the rent arrears may have been outstanding, but I had a disrepair claim and therefore there should have been an equitable set-off. And we know that there's no real argument that he hasn't been given due warnings. Clearly, he had the warnings which allowed him to make the applications to stay execution of the warrants in 2009 to 13.
Are these also like merits points as opposed to a point of law.
I appreciate that, and I will move on now to the merger point. I apologise, my lord.
The merger point is a very short point.
It is. Our simple point is that to have a merger, and of course we rely on Virgin, to have a merger effectively means that the cause of action that we sought in 2017 wasn't available any longer because that had been merged in the judgment in 2008.
Yes.
And quite simply, we say, well, that can't be right. And we say it can't be right for the simple proposition that every time in a weekly periodic tenancy, every time one doesn't pay one's rent after that possession order in 2008, a cause of action arises.
You say a new cause of action arises every rent day.
Every rent day. Now, a landlord could, if they wish to, for example, seek a money judgment for that. They don't have to seek possession, they could seek a money judgment for that. And then they could go for attachment of earnings or whatever. They could seek possession, and of course if they did it too often they may not get that order because it may not be reasonable to make an order, but they could do it. But every time there is a breach of that order, of the tenancy agreement, that creates a cause of action. And then if one says, well, that clearly must be right, but of course that first order that we saw in 2008 has reference to current rent, i.e. future rent. But the difficulty about that is that that does not form part of the judgment of 2008.
The condition.
It's a condition.
Condition for continuing payment of rent under the 2008 order was merely a condition for the continuation of the suspension.
It was actually worse than that in a way. Well, better, depends what side you're on. But what it was is actually saying that you can't get a date for possession as long as the tenant complies with these conditions.
I think that's what I said.
Well, it's not strictly speaking a suspension, but it's a
in that case, it was a postponement.
Yes,
Yes,
probably a distinction without a difference.
But what it is, it's a condition for avoiding a date being fixed for possession.
That's right, absolutely right. There's no money judgment for it. There's no assessment as to whether, in fact, what the rent is for future, whether the proper notice has been served for increases, etc., etc. There's nothing of that kind. And of course, it's a condition that, because it was breached, ended. Because it ended because we know from page 31 of tab 3, a date for possession was granted. And the order that was made in 2008 merely said that the date would not be granted and would be postponed for so long as the claimant complied with the conditions. They didn't. So that goes out of the way. So there's no reference any longer in the original possession order to current rent. It's purely a money judgment. And of course we couldn't seek those arrears anymore. Those arrears have been determined. All the arrears up to 2008, of course, have been determined. And of course they're not susceptible to future action, save under the order made in 2008. And of course, what we then see is a series of orders providing for payments of current rent plus. But again, those are merely conditions. They're not separate claims. They're merely conditions to stay enforcement of the order made in 2008. It's the order of 2008 that's sought to be enforced, not the order of 2009, 2010, 2011. It's the order of 2008, and that's an outright possession order without any provision for current rent being paid any longer. If my learned friend was right, it would mean that Salix Homes, or indeed even if it's still Salford City Council, could not, for example, seek money judgment for any post-2008 arrears. And with respect, what we say the confusion is because the grounds for possession are in broad terms similar.
Or it's the same tenancy obligation.
It's the same tenancy obligation,
And
absolutely
similar
right.
grounds.
Yes, and certainly rent arrears, in broad terms, it's certainly rent arrears grounds. But that doesn't get over the problem of the cause of action is being created each time. Each time of non-payment, I should say. Each time there's non-payment, it's being created. Now, of course, if at any stage prior to the 2017 order, the arrears are wholly cleared, then it doesn't really matter to some extent unless you went under ground 11 about a history of payments. But in this case, that's not the history of the case.
That's it, isn't it?
So that's a simple point we make. The cause of action has continued. It's clearly not part of the 2008 order. It's clearly just a condition relating to the stay of execution of that order or of setting a date in the first instance. And nothing changes from 2013 when the last stay is granted that mitigates against it.
That's like a submission on this point that was raised by my lord before. My lord pointed out, and you pointed out as well, that the second possession, the second possession claim was for two grounds, non-payment of rent and persistent delay.
Yes.
Whereas the original claim was just for non-payment of rent. Does that matter?
Well, the cause of action is the failure to pay the rent in accordance with the terms of the tenancy agreement, which then allows you to satisfy, or argue that you satisfy, a ground for possession, in this case grounds 10 and 11, which are the two grounds you've just mentioned, my lord. And so in that sense, when one looks at it as a whole, it is slightly different, because obviously there's a slightly different requirement.
I mean, I suppose.
But I don't
want to push you one way or the other on this point. I just want to know what your submission is.
It's certainly not our primary point, because it is right.
I mean, I suppose what could happen is, as you say, the rent could be completely up to date, but you could still go for persistent delay. Well, it would be unusual to do that.
Well, it does happen on cases. I say normally on cases where people have a habit of clearing and then getting new arrears, clearing then new arrears, and there's a sense that they're just playing the system. Sometimes
your problem there is, I suppose that doesn't really help you because you want the money, and your real claim is for the arrears. That's what it's really about.
Well, that's right, and as you'll have seen from the 2017 order, despite an uninvolvement by the tenant, we were volunteering an SBO, and we actually said to the court we wanted.
You don't need to go down this route.
No. Where, of course, it might be interesting is if, let's say, one had a situation where Mr. Mantato had cleared the arrears, but not the costs element of the 2008 order. In other words, it hadn't been discharged because that element of the money judgment was still outstanding. And we were talking about a situation after the stock transfer. And if Salix Holmes had said, OK, he's got this problem, but then he gets new arrears and then he clears them. And by the time we were thinking about issuing proceedings, he has no arrears. We might want to be relying on ground 11. And my learned friend's case would be, well, you can't because you're still stuck behind the 2008 order because it's still rent arrears. It's still that condition of the tenancy agreement that applies to the payment of rent. And we say that would be nonsensical. Because in terms of abuse of process, in terms of an unfairness of the use of a process, it doesn't matter, for example, that Salix were perhaps under the misapprehension that they ought to, every 6 years, get a new possession order if there was still a problem. What is relevant is the fact is, well, what is the effect of that? My learned friend says, well, that meant that the court couldn't give scrutiny to the fact that, as to whether a warrant should be issued after 6 years. Well, the difficulty with that argument is that that would produce either a warrant for possession, which would only take you back.
I'm sorry, I don't know.
Sorry.
I think you've lost me slightly.
I'm sorry, my lord.
So, are we still on a merger point, or are we on a slightly different, which is abuse?
I was slightly moving on to the question of abuse, just as part of.
All right, but can we just divide things up? So,
of course.
So, you said everything you want to say on abuse, on merger.
Yes.
And just so I've got this right, the fact that it's grounds 10 and 11 is a relevant consideration. It's not your primary point.
Certainly not the primary point.
But you still rely on it to the extent that you can.
Yes.
All right. And now, so the next question is, even though there was no merger, so logically the next question is, even though there was no merger, so you weren't debarred by law from bringing the second action, nonetheless, it's an abusive process to do so. But that doesn't seem to me to get off the ground, because if you're right on your first, well, yes, you'd have to fail on your first point for that.
Yes, I mean, if we don't, if there is merger, if we couldn't have issued the second proceedings, that shouldn't have been possible at all. To some extent, it's clearly an abuse. I mean, it seems to me that must follow, and you don't need the abuse argument.
So on this point, you're correct. You're correct that there's no merger, but nonetheless is an abuse. But that seems to me a very, very difficult proposition, because if you're correct, the reason there's no merger is that you couldn't have got a money judgment for the arrears accruing due after the first order. Why would it be an abuse to claim them?
Well, if my learned friend is right that we have our cause of action for ongoing rent arrears, an ongoing breach of tenancy condition in respect of rent arrears.
No, but you succeed on your first point.
Oh, I see. Sorry. If we succeed on the merger point, in other
So
words,
if you fail on your first point, that's the end of it. You don't have to consider abuse further.
absolutely.
If you the only question of abuse arises if you win on your first point, but nonetheless for some other reason, it's an abuse to have brought the second proceeding, but that can't succeed.
Well, my Lord, my understanding is that that's not really a separate ground that was pursued in any event by my learned friend. It was really a merger point that was... I mean, the reason abuse came into it was just to see, give it some contextual background, and just to say...
No, but there are many cases, the Henderson type case,
Of course.
where there isn't strictly a stop, but nonetheless it's an abuse to bring the proceeding. So it can arise, but I don't think on the facts of this case it can.
Well, what we would say, in very short submission on that, my Lord, is that it can't arise for this reason, that by going for a second set of proceedings, one goes through the normal pre-action protocol process, one issues a normal notice seeking possession, which gives a warning to a tenant that unless they address the problem, possession proceedings will be issued.
What the district judge seems to have said seems to have taken into account, so I'm looking at page 60 of the core. The first complete paragraph on the page, he comes to the conclusion that the claim is barred by a adjudicator.
Yes.
Then he goes on
No,
to say...
sorry. I think he's setting out here the submissions of the parties.
So is he?
Yes.
Oh, you're quite right.
The actual kind of findings on merger are actually very brief. It's
Yeah,
fair to say,
they're
page
right.
69.
He sets out the arguments.
Yes. He fairly sets out, I think,
But I mean,
both.
I don't know you. All right, you go through this as you want to. You're saying
Well, just
the
very
actual
quickly.
protocol, usual notice.
Rather than have a situation where he's facing a warrant, we backtrack from that and we go pre-action protocol, notice seeking possession, possession claim at which he's entitled to defend. He said it's not reasonable. But even if he doesn't defend, he gets a new SBO. It's no worse position than having a stay of execution for an outright order. In fact, probably better. So he has those protections. Those protections are in place and they are greater. Because if one takes the opposite view and says, OK, what would have happened if we'd have relied upon the 2008 order? Well, either we'd have got permission to issue a warrant after 6 years, and that would have been a warrant for possession. So we'd have got there a lot quicker than by going through a possession process, as we did in 2017. Or we wouldn't have got permission, for whatever reason, and we'd have issued separate proceedings then. That's all that would have happened, because we couldn't just sit back and allow rent arrears to continue being unpaid. I mean, that would be ridiculous. And there can't really be any serious discussion that we wouldn't have been entitled.
Well, I think that's what I was saying. It can't be an abuse, really, to start fresh proceedings for a new cause of action.
Well, exactly, and of course, my Lord, it actually makes it a complicated argument as well for my learned friend, because if the court had refused an application to issue a fresh warrant, the logic of it is you've still got the first possession order extant, because you haven't paid off the costs, so that's still out extant, and you're arguing still, there's no reason not to, just because of a decision on the warrant, you're still arguing that there's merger. Well, that doesn't work, because that means that we can never take any action in respect of rent arrears.
Right, thank you.
So that's our position on that.
Thank you very much. Yes, Mr. Stark.
My lords, as I see the appellant's case, it's that there is a new cause of action that arises every week. That is the heart of its case. We say that's wrong because the cause of action is the statutory ground for possession. The statutory ground for possession is what allows you to seek possession. It's not simply that there's been 1 week's breach of rent. What the statutory ground specifically directs you to is to arrears of rent. Now, what I would say, that's all the arrears of rent. So if we return to the authorities bundle, page 249.
249.
249. Some rent unlawfully due from the tenant is unpaid on the date which the proceedings for possession have begun, and except where that first bit can be ignored, there is a requirement that there needs to be arrears at the date of the notice as well in relation to the ground 10. And ground 11 that's relied upon here, but you will have noted that there were no particulars of ground 11 pleaded. The only thing that was pleaded in the second action...
Just hold on a minute.
Sorry.
You're looking at the ground which, page 240?
249, sorry.
249. Right.
It's
So that's looking at whether rent is unpaid on the date when possession of the proceedings have begun,
Yes.
and was in arrears on the date of service under Section 8.
Yes. That's because...
when Salford were the landlord, they didn't serve any notice under Section 8 because Section 8 didn't apply.
No, they would have had to serve a notice under Section 84 of the Housing Act 1995. It's a notice seeking possession
And
to
that's
the same
not
effect.
part of the ground for possession under the Housing Act. The ground under the 1985 Act. The ground under the 1985 Act we see on page 240, which is simply that rent lawfully due has not been paid. It doesn't tie it to any particular date, whether it's the date of beginning of proceedings for possession or the date when a notice is given. All that matters for that ground is that some rent has not been paid.
Well, for both ground 10, there must be unpaid rent for ground 10 and for the ground under the Housing Act 85. There has to be some rent has been is unpaid.
At some point.
Yes, and the case law said that we don't have access. The case law said that you have to have arrears at the date of issue proceedings for purposes of ground 1.
Right, but you don't have to have had arrears at a date earlier than that, as you do under ground 10 of the 1988 Act.
Not for a specific requirement of the ground, but in relation to the earlier Act, it's been accepted. The purpose of a notice seeking possession is what's called a shot across the tenant's grounds.
So,
And therefore, in those circumstances, you have to be able to show that there is some rent. So therefore, you have to show there's been a notice of seeking possession in compliance with the statute.
I understand that, but the point you're making is that the cause of action is not failure to pay the rent on the rent day. The cause of action, you say, is the statutory ground of possession. And therefore, we need to compare the two statutory grounds of possession to see whether the one encompasses the other.
Well, it's simply, my lord, in my submission, it would be in fact a matter simply of phrasing rather than there being any different particular requirement. And that's because under the 85 Act, you have to show that you have served a notice seeking possession, say in rare cases where you may have to dispense with it. And that notice seeking possession must show that a ground is made out. So therefore, you cannot therefore have an order made under the 85 Act unless at the date of the notice seeking possession there was rent arrears, because ground 1 provided for rent arrears. So there had to be from the statutory scheme. So it's simply a slight difference in wording. There's no difference in the requirements of both statutes. What the grounds of possession are not concerned with at all is when those arrears arose, except for the purpose of whether or not they're lawfully due or not. So it may be open to you to run a
Which
defence
ground are you talking about now?
in relation to both of them.
Well, you say that neither ground is concerned with when the arrears are through, but ground 10 is. It's got two particular dates.
Well, what they both require, I accept they both require there to be some in existence at the date of the notice seeking possession. But what they do not require is for you to show that there have been particular arrears arising on particular weeks. What they require is that there are some arrears of rent. The cause of action for arrears of rent would disappear in those circumstances if you paid them off by the date of the issue of proceedings. There might be a difference in relation to if you were pleading a Ground 11 case on the basis that was what had happened, but the cause of action disappears. So the cause of action...
No, but that's all right. Can I just...
So,
Do you accept that under the original order, you do not have a money claim for rent which accrues due subsequently?
well, it's less simple than that in this sense. One has to look at the whole purpose of the statutory scheme.
Why don't you say it's less simple? You know, you are a landlord and you want to have a money judgment because you want to make the man bankrupt. Could you, as a landlord, in relation to any rent period after the date of the first possession, claim that you can make the man bankrupt on the basis of a court order for that subsequent rent?
There is no reason why you could not seek a subsequent money judgment,
So that cause of action is not barred.
because it's not a cause of action that's based on the statutory ground, it's based on the contract.
Right.
If you think about it, what the statutory ground simply requires or allows...
I know you're going to go ahead, but let's take step by step. So you accept that the cause of action for subsequent rent is not barred.
Yes, because it's a different cause of action. You cannot come to a court and say, I want a money judgment on the basis of ground 1 of Schedule 2 of the Housing Act 1985. Your claim for a money judgment in those circumstances is based on the contractual claim.
But isn't the grant of an order of possession a remedy which is consequent on a cause of action rather than the cause of action itself?
No, because the cause of action itself is the statutory ground. If the statutory ground didn't give you the right to seek possession, then you couldn't, in those circumstances, seek possession. It's the statutory ground that gives you that right, not the underlying contractual claim. So the difference is, if you're seeking a money judgment, you're seeking a money judgment in contract, not seeking it as a result, as a part of the statutory ground. If you're seeking a judgment for possession, you're not seeking that in a contract, you're seeking that on the basis of the statutory ground. So they are in fact two different causes of action. Now it's very common that they will appear in the same possession order, because you want your money judgment at the same time as you want your possession claim. Historically, some local authorities didn't even ask for money judgments because the claims were cheaper. But
the cause of action, has been described in many ways, but it's basically all the ingredients that go to make up your right. Now, the fact of the matter is, although you had a right to possession under the original rules, you also have a right to possession under the Act in relation to your subsequent arrears. And so the cause of action for both of those is a combination of all of the matters that are relevant to it.
But that's why the statutory scheme...
You might have a case of abusive process, but to say that you're precluded, where you have fresh arrears which are not covered in the first action, to say that you are incapable of adding to the claim a claim for possession in relation to those arrears will be a slightly unusual situation.
Well, it would be an unusual situation if one was looking at this simply through the prism of a standard claim for damages, which then someone wishes to make a later claim for damages in respect to the same cause of action. but one has to look at it in the context of the statutory scheme.
Why is it an abuse? I mean, the whole thing about causes of action at Stockholm, it's all based on the abuse of the system. Why is it, if you have to sue anyway to get a money judgment for your freshly accrued arrears, if you have to do that, why is it an abuse to add a possession claim to it?
Because you already have a possession order in respect of the statutory cause of action. Your only right to get a second possession order is based on you saying that the statutory ground is made out.
Yes.
But you've already made out the statutory ground, and you've got a possession order in respect of the statutory ground.
Yes.
And the statutory scheme is immensely helpful to both landlords and tenants because of its flexibility. Because the original suspension orders are required by Section 85.3a and Section 9.3a, save in very rare exceptional hardship circumstances, to make provision for, in the order, payment of the current rent as well as any arrears of rent.
So why can't that be? Why is it harmful to the tenant for exactly the same power of the court in relation to fresh arrears? Why is that oppressive to the tenant?
Well, there are various reasons why it could become oppressive. Consider this, for example. You had, in this case, the second possession order was made in the complete absence of knowledge of the first possession order. The learned district judge found that the housing association had failed to comply with the practice direction. I'll take you to the practice direction.
Who'd failed to comply with it?
Look, the housing association had failed to comply with the practice
The landlord.
The landlord had failed to comply with the practice direction.
Well, one might have thought that disclosing the history of the matter on the second action would have done your client no favours because of the order that Deputy District Judge Griffith made on the 12th of December 2013, saying this is his fourth application to suspend. If he failed to comply with the terms of the order, it's unlikely the court will allow a further suspension. So the likelihood of disclosing the history of the claim in the second action would be an outright order.
Well, not necessarily. And if one looks at the rent account in this case, I can suggest why it's not necessarily the case. And that can be found at the back of the supplementary bundle. The very last time in the supplementary bundle.
Yes.
Now, Deputy District Judge Griffith's order,
Which when you say it's all, I'm not quite sure who these judges are. Is it the first or the second?
Deputy District Judge Griffith's order in the first set of proceedings.
First, the 2008.
Yes. If you turn to page 103 of the supplementary bundle.
3.
3.
Yeah.
Yes.
You will see that as at the 11th of December 2013, which is the last, there had been a payment of £700 and the arrears were £2,506.45.
Yes.
Over the next period of time, the arrears fell significantly. Such so that at one stage on the rent account,
Page 108.
yes,
25th of November 2016.
you're ahead of me. Yes, the arrears had fallen to £82.
Yes.
And it's only in the short period after that that then a problem arises again.
Yes.
So what the judge on the second hearing would have seen was not a situation where they would be faced with a situation where the arrears are considerably lower than the last time the order was suspended in the original proceedings. That would be a relevant factor for that judge to take into account, because the judge wants to know what steps have been taken to recover the arrears. And that means the arrears as a whole in the context of a possession claim or for a statutory ground. You can't compartmentalise in that regard. My learned friend in his skeleton below accepted there'd been constant arrears throughout the whole term from the first order. They'd fallen very substantially, they'd risen.
So the judge needs to know the full history to decide whether to suspend it.
Yes, and also, well, it depends. If you were looking at it under the first order, and the judge was being asked, well, should I now, because the first order was after 6 years, as my lords, you're aware, you have to get permission to issue a fresh warrant. And what the rules require is you to explain the delay. Now, in some circumstances, if it's been clear that the arrears arose several years ago, and you've sat on it, and not done anything for several years, a court may say, well, we're not going to give you permission to enforce this.
It's a new warrant or new order.
And that would be a new warrant, if you'd applied under the first set of proceedings. But in other cases, such as this, it may well be that the judge will say, well, the arrears have gone up a bit again, and what I think I'd like to do at this stage is possibly order a hearing, because these applications can be made, and I'd like to direct that the tenant attends, because I'm a bit concerned why there's been such a falling off, having reduced the arrears to £82. Because a judge on the application to suspend, sorry, not to suspend, an application to issue a warrant out of time, the rules do require you to give reasons for the delay and to set out, therefore, the full background as to what's happened in the proceedings. So the court would be fully informed at that stage as to whether or not it should issue a warrant, being aware of the whole rent history under the possession order. Now, in relation to the second claim, in this case, the rules of the practice direction requires that you just go to the right page.
This point about the practice direction goes to abuse rather than estoppel merger, is it?
It does, but my lord asked me a question about what might be the consequences of second proceedings, so that's why I've drawn it to your attention. Also, if you have two possession orders, what if you have a situation where the two orders provide for different suspension terms? Now, in this case, it could be said, well, that actually could be said to have assisted my client because the suspension term under the 2013 order was substantially higher. But you could have a situation where the original order was, say, for rent plus £3.60, and then the landlord issues a new proceedings and asks for rent plus 20. The tenant may have got into arrears under the first one, but then does their best to get back in accordance and compliance with the first order. But the landlord then seeks to enforce an order on different terms. Well, that leads to extraordinary uncertainty if you're allowed to issue two sets of possession proceedings under this statutory scheme. Which one is the tenant meant to comply with in those circumstances? Now, that can be avoided by two things. One, by making sure you don't start a second set of proceedings when you already have an enforceable possession order. The second way of avoiding it is the criticism that the learned district judge rightly made, we say, of the landlord in this case, was they'd failed to tell the court about the first possession order and the proceedings in the first possession order seek to recover the arrears.
But this seems to me to be all about abuse rather than legal impediment to actually starting the action. These are practical consequences.
Yes, well, I'll go back then, perhaps to the question of merger. If one turns to what Lord Sumption said about merger in the Virgin case, which is in the authorities bundle, paragraph 17 of his judgment.
Was that 1-7? 1-7.
Paragraph 3 is 1-7, my lord, that's right. And that can be found at page 188, where he lists the various different types of abuse of process and adjudicatum. It's halfway down, just below letter D. There's the doctrine of merger, which treats a cause of action as extinguished once judgment has been given on it, and the claimant's sole right as being a right on the judgment.
Sorry, where are you? Page 188?
188, my lord judge.
Letter D.
Yes.
The essential fallacy.
180. Paragraph 17.
188. 188.
So we're looking at the reference to Unilin and Berry Floor, are we?
Oh, it seems that my bundle is differently.
It's page
Number to
180.
yours.
It's page 180 internal.
Oh, internal page.
188 is
Yeah,
the.
I beg your pardon.
I'm sorry.
Right.
Sorry, then I was
Right, paragraph 17.
Perhaps something. So third is the doctrine of merger, which treats a cause of action as extinguished once judgment's been given on it. Now, if you recall my point is, the cause of action for possession proceedings is the statutory ground. Has judgment been given on the statutory ground? Yes, it has. The
We
claimant's
need
sole
to look
right.
at the definition, the classic definition of cause of action in the Tang and Cooper. It's all the ingredients that go up to make it.
Well, I agree, but of course, my lord, all the ingredients include the statutory ground itself.
Oh yes, I'm not saying it's not.
Because the factual basis and the statutory ground.
Yes.
The factual basis is that there are some arrears of rent.
Yes.
And there
you
are
say that the statutory ground under the 1985 Act encompasses differently drafted statutory ground under the 1988 Act.
Because in substance they are exactly the same. In substance they're all about, are you in arrears of rent? In both cases, the only claim, only particulars given, are arrears of rent. This is not a case where there's been a claim for persistent delay and then set out or pleaded separately. The persistent delay is absorbed in the fact there are arrears of rent.
Well, if there had been pleaded out persistent delay, would you say that was covered by a merger?
It may be that it will be more proper to say that that is covered by abuse of process. The reason being this. Because of the way that the statutory ground gives you the right to a possession order, it then gives you the right, under 9.3 in this case, to have an order made for the current rent. So you're in fact in a much better position under the order, because once you fall 1 week in arrears under the order, technically you're entitled then to apply for a warrant of possession. Whilst persistent delay would mean you were showing lots of particular delay, and not merely lots of particular delay, but there's only been one reported case on this, as far as we run. I can obviously get it to your lordships, Etherington and Burt, in which Mr. Justice Fulford suggested that persistent required you to show some form of positive inaction or action on behalf of the tenant. So if, for example, a tenant fell into arrears because of housing benefit problems that weren't their fault, how could that be persistent delay on their part? So persistent delay may well require different elements to prove the cause of action than simply the basic arrears of rent ground. So the substance of my point is one looks at this as the whole statutory scheme. The statutory scheme says that your cause of action is the combination, I accept entirely, my lord, that there has to be the factual basis for it, but what makes it a ground of possession, what makes it a cause of action that can be enforced in this case, is the statute saying it is one, that it's a statutory ground for possession. Is that...
Why is this different? Why is this different from any case where you may have several reasons for the same relief? And there may be several collections of fact which may entitle you to the same relief. So why shouldn't it be that just as the arrears of rent up to the date of the 2008 order gave you a right to not only claim the sums outstanding plus possession, why shouldn't you say, and the arrears of rent accruing thereafter gave you a right to a separate money claim and a right to possession? I mean, there are many, many cases where the facts might give rise to the same relief.
But, my lord, that is catered for in how the statutory scheme is worked out, in that they are simply particulars of the ground for possession. There is one ground for possession, is that there is some rent that is unpaid. In the way that this statutory scheme works, you make your claim on the basis of your statutory ground. If you prove your statutory ground, you then have to show it's reasonable to make a possession order. They're the two fundamental requirements before you can obtain a possession order under this Act.
Well, I'm not sure
What-
you can say much more about this. I mean, you made that point. You made the point. You make it very effectively, but you're at the end of the day, your point simply is on the cause of action merger. You're saying the cause of action here is under the statutory grounds. The statutory grounds are in substance the same. Query, not ground 11, ground 10, and therefore they're the same. There's an estoppel cause of action, estoppel so far as the possession is concerned, and a murder. That's it. That's your case.
It is, but if I can go slightly further in that, of course, what is the purpose of the merger jurisdiction? Is to ensure finality in litigation, whether it's finality between the individual parties or as a general rule. And Section 49(2) of the Supreme Court Act, in a provision that was originally brought in because of the merger of law and equity, specifically enjoins courts to avoid the multiplicity.
Is this the Higher Courts Act or the Supreme Court?
Senior Court.
Senior Court. Well, I'll call it senior. Senior Court.
It's a tab 1 of the supplementary authorities.
Yeah, but you've got to sue anyway. I mean, I understand that, but there's no finality because you've got to sue anyway for the new rent.
Yes, but that's a different judgment in relation to a different cause of action, in relation to a different remedy.
Yeah.
So that's not a good reason for saying you should have two possession orders, which is the same remedy in respect of the same cause of action.
Yes.
And that if you apply for the same remedy in respect to the same cause of action, that is a classic principle of the doctrine of merger. If I can take you to just
Right, let me put it a different way then. Can it be the same cause of action when what you're relying upon is a statutory ground and there are two separate statutes that operate under different regimes when the property and the tenant have different statuses? So you may be right in saying that let's assume for the moment you're correct in saying that in substance they're the same. The fact of the matter is, one applies where the tenant has a certain status and the landlord has a certain status. The other one applies when the tenant has a different status and the landlord has a different status. So why is that not a different cause of action? It may be in substance the same, but the facts that you need to prove to establish that ground are different. So in the one case, you have to set out and establish the landlord and the tenant conditions. In the second case, they're not the same conditions, they're different. Why is that the same cause of action?
Well, firstly, my point was originally that the fact they are the same, it's just that the requirements turn up in different parts of the statute.
But there's different statutory, they're different statutory regimes.
The only thing that's different about them is because they relate one to a tenant of a local authority and one to a tenant of a housing association.
I know, but that's vital. That's a vital part of the cause of action.
But I must admit it's not vital because in substance the statutory causes of action are the same.
Right, I've got that point.
So
Would Salix be able to enforce the possession order given to Salford, even though doesn't satisfy the landlord condition? I mean, is that a possibility?
yes,
It can.
it's very. What normally happens on these large-scale voluntary transfers is that there is a long list of them are simply sent to the court and they're substituted as the original party.
And you can do that even though they don't satisfy the landlord condition?
Yes, because they are the landlord.
But they don't satisfy the statutory landlord condition.
Yes, but the statutory landlord condition is not for the purpose. There is case law in this case called Knowsley Housing Trust.
All right. You say there's authority.
Yes, it's commonly done,
right.
because otherwise, what would have happened in all these large-scale voluntary transfers? All these houses, they'd have to start fresh proceedings against everyone, and they might have 2,000 or 3,000 people on suspended possession orders. So they're commonly substituted in those circumstances.
I should just say, just for sake of clarity, I don't dispute that, and I think it's CPR 19.2, subparagraph 4, which talks about the ability to take over claimant can substitute a claimant in the case where the same interests apply.
Yeah.
And I think in other cases that may be what happens upon stock transfers, for example, for antisocial behaviour orders and such like. Sorry, James.
And indeed, my lords, you'll see, but below this, there was no issue raised that they were, in essence, privies for the purposes of the merger doctrine. And therefore, that because they could enforce that first possession order in respect of substantially the same cause of action, namely the statutory ground for rent arrears, then they can be substituted. And that's why, if they were different causes of action in those circumstances, then there might even be a significant difficulty in allowing them to take over. But they're allowed to take over because it is in substance the same. It's in substance the same.
I'm not sure it is the same issue. I'm not sure about that. I mean, the fact that where there is a possession order against a tenant, the circumstances in which you can be substituted or take over maybe nothing to do with the convenience. But that's a different thing from saying what constitutes a legal cause of action according to the Tangle-Cooper definition. That is all those ingredients which it is essential for you to establish. The ingredients which is essential for you to establish in order to bring your claim. And in this case, in order for this landlord to bring a claim, they had to satisfy certain requirements in respect of the property, the tenant and landlord. I hear your point and we'll have to think about it, but I'm not at the moment convinced that isn't an essential ingredient of the cause of action.
Well, if we can just stick to one authority on the point of substance, and that's in the supplementary bundle. It's Green and Weatherall, page 340.
This is under the authorities bundle, yes, which tab?
The supplementary, the short supplementary authority bundle.
So it's under yes.
It's tab 3.
Yes.
Now, in that case, which was a case concerning a defendant had been sued in respect of a sum of money which was said that she'd taken from an estate that she wasn't entitled to. And then it was suggested that she could be sued on the basis of a different cause of action. So what happened? The court gave judgment against a married woman who was a defaulting trustee. Ordered the judgment satisfied her separate estate and execution proved useless. It was not open to the plaintiff a new action obtained against a judgment in a different form for payment of the monies into court. As against her, the action was raised judicata. And what Mr. Justice Morn went on to say in relation to that can be found in the judgment at page 221. These were trust monies, and they didn't actually form part of her estate of the trustee. He observed that monies forming part of the trust do not, in truth, form part of the separate estate of the defendant trustee.
This is 221. Which line?
221. Page 348 at the bottom. Sorry.
Yes. Where is it at the top?
It's in the it's halfway down the first paragraph.
I would observe that. I have it.
It's after made.
Yes, thank you.
We observe that monies forming part of the trust do not in truth form part of the separate estate of the defendant trustee, and it would seem that the plaintiff in such a case must make up his mind with decides to allege and prove that the defendant has committed breach of trust, and is therefore liable to the extent of a separate estate in respect of whether he desires to treat as a trustee possessed of trust monies, or desires to place in safe custody. In my opinion, it must be admitted that the cause of action in the two cases is not strictly speaking the same. On the other hand, the plea of res judicata is not a technical doctrine, but a fundamental doctrine, based on the view there must be an end to litigation. In the last case observed that Lord Dortmund delivered the judgment, cites from the digest and then relied on a maxim that must be beyond my legal Latin. But in the course of that case, there had been a previous judgment, and you could not go back on that previous
But
judgment.
this can't survive Virgin, can it? Because Virgin says quite clearly that Mr. Justice Morn is talking about the broader principle that's why he refers to Henderson and Henderson, which Virgin says is a different principle.
Well,
Virgin says quite clearly that res judicata
yes.
is a rule of law. It's not a broad merits-based judgment. It applies where the course of action is the same.
Well, if I can take you to what Spencer Bauer says about this in the context of merger. And the extract from Spencer Bauer is at tab 2.
Is this a post-Virgin edition?
No, it's pre-Virgin edition. It's at page 335. Two actions, 2103. Two actions may be brought in respect to the same factor that give rise to distinct causes of action. So that's my point in relation to the money judgment, is a distinct cause of action. But if the causes of action are substantially the same, the plea of formal recovery prevails despite formal differences or different remedies. Now, Virgin doesn't say anything to contradict that in my submission. When Virgin talks about the doctrine of merger, which of course wasn't actually an issue itself in the Virgin case, it refers to treating a cause of action as extinguished once judgment's been given on
The
it.
footnote refers to Green and Webber, which you just showed
Yes.
us. And the editor's comment at the end of the footnote is that there were alternative remedies for one cause of action, and the plaintiff had to elect. So that's how the editors explain that.
Yes.
It is the same cause of action.
Indeed, but of course what Mr. Justice Morm said is that technically they're not the same, but fundamentally, because of the purpose of the doctrine of res judicata, they are.
Well, that's on that, because the cause of action was for breach of trust. In both cases, the cause of action was for breach of trust, but the remedy they sought was different. So in the first case, as I see it, I'll read it very quickly. The remedy they sought was to go against her separate estate as a married woman, I understand it, but she parted with the money, so there wasn't any. They then sued her as a trustee, her capacity as a trustee, and for what she should account for as a trustee. And that was the same cause of action based on breach of trust, but it was a different kind of remedy. That's what I saw it at the moment. I'm sure that really helps you here.
Well, it's simply in relation to the establishment of the general principle that when one is dealing with questions of res judicata,
Yes.
one's looking at the fundamentals, not slight
Well,
technical
I think it's on that
differences.
point.
That's the point.
Understood.
But if I can go back to Virgin,
Yes. Yes. Bundle of authorities 30.
yes.
Thank you.
The purpose of the abuse, and we're dealing with abuse in relation to any of these principles, paragraph 25 on page 193, I'll take the bottom of it.
Which page?
Page 193, that tab, it's a little letter G on the left-hand side of Virgin. Res judicata rule of substantive law, while abuse process consequently informs the exercise of the court's procedural powers. In my view, they're distinct, though overlapping legal principles with a common underlying purpose of limiting abusive and duplicative litigation.
Yes.
And the reason that we say that this falls within that is that it is duplicative litigation in respect.
Yes, but you've got to go back to where he starts, where he says that res judicata is a rule of substantive law, while abusive process is a concept which informs the exercise of the court's procedural powers. Although they have similar purposes. They are distinct things. One is substantive and the other is procedural.
Well, distinct but overlapping, as he
Yeah.
puts it. But the point that I'm making is that in relation to merger, the principle behind the doctrine of merger is to prevent abusive and duplicative litigation, because you already have all the relief that you need. Now, what's odd about this case is that, of course, in most of these cases when there's been a dispute, it's because someone hasn't achieved all the relief that they need. They've been seeking further relief, and there's been a suggestion, well, your cause of action is merged in that judgment, you can't do anything about it. There's a very great difference in this case, is that they have all the relief that they need. They have a judgment in relation to the possession, which requires the tenant to give up possession if they don't comply with the terms of the order.
Yes, but I put this to you. There's the nub of the matter. They have a judgment for possession, but that is relief. And the question we have to ask ourselves is, what do they need to prove to get that relief? And to get that relief, they need to prove the facts set out under the Housing Act. And those facts that they need to prove are different from the facts that needed to be proved by the local authority. It's a relief, it's a remedy. Like damages is a remedy. The cause of action is everything you need to prove to get that relief.
And the cause of action, my lord, is arrears of rent.
But it's
Which you already
it's arrears
proved.
of rent owed by a certain type of tenant to a certain type of landlord.
On two particular days.
But, my lords, that would be, in my submission, indeed, looking at this in an extremely technical manner. You have, in those circumstances, a cause of action that is subsumed in the judgment. You have a judgment for it. Unlike most cases, where you do not have the circumstances of this statutory scheme, you can't enforce in relation to later rent arrears that arise. But in this case you can, because of the way that the Act is designed. The Act is actually designed to stop two claims being brought. Because otherwise you fall into all those potential difficulties that I've outlined earlier. The whole purpose of the statutory scheme is you only need one possession order to cover not merely past rent, but for the current and future rent.
Mr. Stark, we're dealing here with a case where it's agreed that there were continuous arrears of rent. It never stopped. In a case where the evidence was in dispute, where the tenant said, yes, I did clear the rent then, completely, there were no arrears, although there may be costs, but more arrears arose. And the landlord says, no, the rent was never cleared, the arrears were never cleared off. On your analysis, you would have to try out that factual question on the first action, conclude it, get a ruling, and the landlord, if the tenant was cleared, the landlord would have to go off and start again.
Well, that would depend very much on how the order's drafted. In fact, what's interesting about these orders, you'll see that the first order had a proleptic discharge provision in it, as it was described by Lord Newberger in Knowlesy and White, whereby it looks at the future and says, well, if you've complied with all the conditions, then automatically the order falls. It's except in this case that didn't happen, because there were constant arrears. The new order, the N28, the second order, doesn't contain a proleptic discharge provision. So the consequence of those orders could mean that you actually clear the arrears, but the possession order continues unless you make an application under section 9.4 for that order to be discharged. So you could find yourself in those circumstances being picked up again, even though you have cleared your arrears. If you then fall into further arrears, the possession order continues to bite on it.
In other words,
but that doesn't undermine my lord's point. You're making a different point. You're saying in some sense it can be beneficial. My lord's point was, if you're right and there's a dispute, as there might have been in this case, because we haven't got to this now. We don't need to. But it might be said that in fact all the arrears have been paid off. Because if you were to appropriate all income that comes in against the oldest amounts due, which a landlord could do in the absence of appropriation by the tenant, that £82 would have been paid off by subsequent payments in. Now, nobody's raised that point here, but you could get at exactly the sort of dispute that my lord has indicated.
My lord, no, they say, because of the nature of these orders. Because they are running orders, then what one looks at is the cumulative level of arrears. So if you look back at...
But the running order is incidental. Your point has to survive orders that do have running orders, that are proleptic, and orders that don't. So if we are in the situation, as you described, and the rent arrears were paid off, but yet arrears rose again, it would be logical, given your position, for the landlord to say that doesn't matter. Would it? I can continue, or would it be right for the landlord? Would the tenant say, well, no, if I prove they were all paid off, you've got to start again, and that happens in the first proceedings, and we go through the hoops.
Well,
I don't understand how your
that
answer
is,
is.
in my submission, a consequence of one trying to chop up the statutory ground into different pieces depending on when the arrears arose. Now, I accept that if you have a situation where you have a proleptic discharge order, we look at it from that basis first, and a proleptic discharge order comes into effect, then there's no judgment anymore. And new arrears arise, then clearly you can bring fresh proceedings on the basis of those new arrears.
And the 2008 order was exactly such an order.
Yes, it was an order, but it's accepted it wasn't paid off.
Why are you right about that? Because if your argument is it's all you've got to prove is what's in A and B, if you have proceedings for possession issued at the date when the proceedings are issued, and you're in arrears again when the service happens, why need there be continual arrears between the two?
I'm sorry, Lord, I'm
You say here are the ingredients for the claim. They are only A and B. If there's unpaid rent when the proceedings for possession have begun, and arrears at the date of the service of the notice, but no arrears between the two, why does that require two actions?
Well, no, the situation there is you have a situation where there were arrears at the date of the, so when arrears then when the proceedings have begun. But again, it comes back to the same point in that they are all part of the statute. The statutory ground is not interested.
Well, that's your point.
Yes, the statutory ground is not interested if it stopped if there was a gap there between the two. The statutory ground is interested in whether or not the statutory criteria are there.
All right. No, I think we've got. So I think you've got your central point. It's the same. It's in sub. I mean, it comes in substance. It's the same cause of action, and the object is to avoid duplicative proceedings. And you say that there are, in any event, practical reasons, such as in this case, the failure in the second action to tell the judge about the previous course of action in the previous order. I think we've got all those points now.
Yes. My final point in relation to the purpose maybe is to cite something that Lord Millett said in Johnson and Ball that is cited in Virgin by Lord Johnson.
Right. Which term?
Is this page 193?
We're back to
Virgin.
Oh, in Virgin.
Yes.
One bundle, page 193. Is that the quotation you want?
Yes, my lord, it is. And it's simply reminding you of the purpose of admitting all types of regulatory contracts, except the purpose, including the purpose of the merger, is, look, normally it says halfway through that paragraph at D, these various defences are all designed to serve the same purpose, to bring finality to litigation and avoid the oppression of subjecting the defendant unnecessarily to successive actions. My point in this case is that the second action was completely unnecessary.
Well, only as far as possession was concerned.
Yes, but of course, that just simply returns from the point about there being completely separate cause of action.
But they had
from
to
money
bring
judgment.
proceedings in any event, so you're not going to have fewer proceedings, are you?
Well, except there, of course, there are different types. If you bring a debt claim, subject to debt claim, that can be dealt with by way of summary judgment. There's no need for a hearing. All those issues can be simply dealt with that way. Then you can have an order requiring money to be paid out, if necessary, in support of the money judgment. But again, the statutory scheme, to an extent, assists very much in relation to authorities or housing associations if, for example, the tenant is not better off. Because the terms of the payment of the arrears can be substantially varied. So you can see in this case, went at one stage from £3.30 a week up to £95 a week. But the substance of the whole case is that they sought 2 claims for possession on the same statutory ground, and that is, we say, barred by merger or by the wider doctrine of the abuse process, especially when we look at the potential consequences of allowing there to be 2 possessions.
Right, so two claims for possessions on the same, in substance, the same statutory grounds.
Of the same house. Of the same house.
The same house. Leading to merger or abuse.
Yes. And if I can just make one final point in relation to abuse as distinct from merger,
Yes.
about the difficulty in particularly having 2 separate proceedings where information is not put before the court. And that's the way that these statutory schemes have been developed over the last few years, is that landlords are now under increasing obligations to provide information to the court. And that's because the court, it's been accepted that people do not turn up for possession hearings. They might not turn up for a multiplicity of reasons. But landlords are required to give that information to the court. If you have a situation where there can be 2 different sets of possession proceedings, where you don't inform the second court, then you are faced with a potential situation, as the district judge rightly said in this case, is that the order that was made could have been very different had the judge at the second stage been informed of all the history of this case.
What is it, just so we've got this, what is it that they should have done under some practice direction they didn't do?
They didn't inform...
Yeah, but where's the, you were going to
yes,
stress
I'll
some
take you
practice
to
direction.
the practice direction. It's right at the back of the authority handbook. In tab 20,
Tab 20. Is this CPR, is it?
yes,
Thank you. Yeah.
and you'll see the information that's required starts at page 290.
290.
Thank you. Particulars of claim.
In relation to residential property let on the tenancy, the amount due at the start, in schedule form, the dates and amounts of all payments due and payments made under the tenancy agreement for a period of 2 years immediately preceding the date of issue, or if the first date of default occurred less than 2 years before the date of issue from the first date of default, and the running total of the arrears. Daily rate of any rent and interest, any previous steps taken to recover the arrears of rent, with full details of any court proceedings.
Sorry, that's 2. What was the next one?
4 over the page. Any previous steps taken to recover the arrears of rent with full details of any court proceedings. And then any relevant information about the defendant's circumstances, in particular the defendant's receipt of
So
social
what
credit.
they didn't do is they didn't mention previous steps to take to recover the arrears of rent, and they didn't cover 2.32.
Yes, I think the schedule was only for a few months.
The schedule has to go, if the first default occurred more than 2 years ago, you start from 2 years previously.
Yes, there is a
What did
provision.
they attach?
It goes back to the core bundle,
They went back to March 2017.
March 2017.
They didn't go back far enough.
They should have gone back to May 2015.
Yes.
they had gone back to May 2015 and told the court what previous steps they'd taken to cover those arrears, that would not have included anything about the past history of the first action, where the last order was made in 2013.
Well, that again depends, my lord. If one takes, looking at the purposive nature of these proceedings, is that one looks at the history of the tenancy as a whole. And the reason one needs to look at the history of the tenancy as a whole is because you have to be satisfied that it's reasonable to make a possession order.
So you construe any previous, in paragraph, subparagraph 4 of the practice direction, any previous steps taken to recover the arrears of rent to mean any previous steps taken to recover any arrears of rent, no matter when those arrears accrued due during the course of the tenancy.
Yes, unless you had a complete situation where there had been a private district order and then there was no relevance at all with the previous arrears. It's because one has a constant, the arrears been arrears constantly throughout the tenancy, then that is relevant. But I accept that's a secondary argument to my main argument, which is that these proceedings should not have been brought at all.
Yes, of course.
May I just
Yes, of course.
My lord, that's all I have to say.
Thank you very much. Yes, Mr. Nagel.
My Lord, just very briefly on firstly, submissions on the merger issue, and secondly, the abuse of process issue we've just heard. With respect to my learned friend, in terms of how he puts the case today, in terms of saying it's a statutory
Yes.
cause of action, in other words, the ground for possession, and that's where everything leads from. The one issue it does fail to take into account is not only, as has been already indicated, the question of the different grounds relied upon by Salix because of the changing nature of the occupation, but of course that it ignores the temporal issue.
The
Temporal issue.
temporary, yes.
In other words, I think it's paragraph 17 of my skeleton argument where I referred to Latanga Cooper. When looking at the facts that assist finding a cause of action, of course, one must look at the facts in terms of time as well. And therefore, at the time, in 2008, which justified the ground 1 finding, that's were the facts that were relevant. In other words, mattered up to 2008. The facts that took place thereafter didn't find the cause of action which allowed reliance on ground 1. And that's an important distinction. Of course, I indicated earlier there may be a case where Salix Homes, being insured, being a housing association, may wish to proceed on a mandatory ground for rent arrears because of history under ground 8, and if my learned friend is right, arguably, it's not clear in terms of whether it falls within his exception, but whether in fact they could do a ground 8. In other words, the 2 months arrears or the 8 weeks arrears of the date of notice and the 8 weeks arrears of the date of hearing, and they could have gone for a mandatory order. It's unclear whether my learned friend says that would have been possible, or whether that would have also, in his case, been affected by the question of merger, because it's still rent arrears. And
So you're going quite fast there.
Sorry,
so there's a ground 8.
There's a ground 8.
Which is available to Salix.
It's in part 1 of Schedule 2 to the Housing Act.
Let's go to the point first. There's a ground 8 available to Salix, which is a mandatory ground.
Yes.
And you're saying that's also based on arrears of rent.
It's based on arrears of rent.
And you're saying the argument leaves open the question whether that would be the substance of the same course of action.
Exactly. It would still be reliant on rent.
Was there equivalent to ground 8 for the local authority?
No, there wasn't. There was only discretionary grounds for the local authority. It's only recent there's been an introduction of a mandatory ground for local authorities.
So there's no such for the local authority in 2008?
That's right. And for rent grounds for the assured tenancies, whether it's private landlord or housing associations, you've got ground 8, which is mandatory ground 10 or 11.
Right.
And as with the ground 11, of course, and as with the ground 10, which talks about particular times of which arrears must be it is, of course, very much a temporal issue, and therefore we say that therefore it can't be bound by doctrine of merger. Because my learned friend says, well, one of the reasons for the doctrine, of course, is finality. We need to have finality. Well, of course, we're standing here today in a situation where this gentleman, unfortunately, still has over 4-figure arrears. And it's, I wish I were my learned friend could say, but it is a situation where, unfortunately, this has been going on now since 2008. And whichever route one took, whether one took the route of applying for a permission to issue a warrant out of time after the 6 years or issued fresh proceedings, the arrears problems has persisted. The finality question and the desire quite properly to treat judgments as final judgments wouldn't have actually assisted this case because it has continued in any event. It's not a principle that assists the facts of this case.
Yes, a new cause of action for a money judgment would be required, but it doesn't really meet Mr. Stark's point that as far as possession is concerned, you could rely upon, he says, the original possession order.
Well, it may be, for example, that Salix homes, they are a social landlord. As I say, they have certain considerations which perhaps a private landlord wouldn't have. It may be that they're happy, as indeed they were, to agree a suspended possession order. Now, in respect of the order that we had in 2008, of course, we had an outright order. Now, it therefore means that it makes little difference to Mr. Mantato whether they sought to make an application under the first one or under the second one. It makes little difference in that sense, but of course they would still have to get over the problem that they couldn't enforce that first order until they got permission of the court to do so. And of course...
Well, what about the point there that is made by Mr. Stark, which is that what is the tenant to do if there are 2 outstanding orders for possession, but with different, but in practical terms, in practical terms, there are different conditions for non-enforcement. So it's true that under the first order, you've merely got a suspension of the warrant, but that's on various conditions. Under the second order, you've also got an order for possession this time, but that's suspended on certain conditions to payment. They're not identical. What is the tenant to do?
Well, our position on the first possession order, once we got the second possession order, is that the first possession order wouldn't have been enforceable. It wouldn't have been enforceable because if we had applied, having got the second possession order, if we had applied not only to replace Salford City Council as claimant in the first action, but also applied for permission to issue a warrant outside of 6 years, it's unlikely that the court would accede to that request after we had...
Well, I appreciate that, but that's on the facts of this case, that we have to look at a wider application. Let's assume you're within the 6-year period, so you don't need permission.
Well, if, for example, that concern has come about because of a failure to inform the court that there was already an existing court order on exactly the same issues of rent arrears, not because of merger, but because of abuse of process, there may be an abuse of process argument there, that wasn't put to the court. But that's not the case here. There's an outright possession order at best in respect of 2008. As far as, but certainly on the facts, I think that's the way you would have to treat it, as an abuse of process argument. And if you had a situation where, for example, a landlord every year went for a separate possession order, being the same landlord under the same statutory provisions, and just didn't, for whatever reason, tell the court that they'd already got their 3 or 4 previous orders, there will be an abuse of process. And of course, in terms of the more central abuse of process arguments, my learned friend talks about the fact that there should have been compliance with the practice direction, which of course is right, there should have been compliance with the practice direction. It's unclear, and I can go no further than that to say that it is unclear in terms of whether the schedule was provided. And the only reason I say that is I'm looking now at page 89 of the supplementary bundle. This is tab 8.
What is unclear? It's unclear.
It's unclear exactly what the position was in terms of what happened at the hearing. Because because at page 89, this is a letter between Mr. Mantato.
This is Salix to Mr. Mantato.
That's right.
So
That's right, my lord.
doesn't tell us anything about what the court was doing.
Well, all it says is, and this is underneath the bullet points, my lord, is I've included a rent statement for the last 2 years, which is what we provide to the court in all court cases. This will show your payments as you requested. I say, however, 2 real points on this. One, of course, is that even if there had been a breach of practice direction, that in itself isn't enough to necessarily form an abuse of process. It's certainly not enough to invalidate any step taken in the proceedings, such as an enforcement of the possession order, and we know that from CPR 3.10. In terms of the context of this case, what we have is a situation where arrears has already been...
what was the reference then to the CPR?
CPR 3.10, my lord.
What does that say?
It says that where there's been an error of procedure, such as a failure to comply with a rule or practice direction, A, the error does not invalidate any step taken in the proceedings unless the court so orders, and B, the court must make an order, may make an order to remedy the error. And in any event, when one looks at the schedule of arrears, we have a situation where it has already been noted at page 108 of tab 10 of the supplementary bundle. One is only really looking at the position from November 2016 at best, because at November 2016 we had £82.04 arrears. There wasn't arrears before that, and so in terms of trying to prove, for example, for ground 10 arrears at the date of notice, that information was provided in the particulars of claim in that very short 3-line schedule you've seen at the end of page 95. In terms of persistent delay, that would have been obvious from that schedule as well, because there'd been no payments since that last payment put down in the particulars of claim at the schedule of page 95.
I'm not sure I followed this.
I'm sorry, my lord.
Explain to me the point you're making.
Well, this is a claim for possession on, firstly, arrears at the date of notice,
Yes.
and arrears at the date of issue.
Yes.
That information was provided in the particulars of claim. The second ground of claim was persistent delay in paying rent, ground 11.
Yes.
And that short 3-line schedule at the end of the particulars of claim that you saw earlier, I think at page 95, indicated that there'd been no payments towards the rent account. Just getting the reference for you. This is page 95 in the core bundle of tab 10. There were 5 date references, and it showed there'd been no payments since the 12th of March 2017 through to and including the 23rd of April 2017. In other words, there had been the weeks missed between those dates. So in other words, there had been a persistent delay on any analysis between those dates. Now, Salix could, of course, have made the case even better by providing the schedule showing a longer period where there had been a history of non-payment. But of course, it doesn't necessarily helps the defendant's case in such a matter for them to have done so. It's clear there was persistent delay. It's clear that ground 10 was satisfied. It's clear that the court agreed and made the order which it was entitled to make, and that's not disputed. It was entitled to make it, save for the merger argument and abuse of process argument. So in terms of any abuse of process, in terms of any, even if there had been a failure to provide the 2 years, first of all, there's a question of whether it needed to be 2 years as to when the arrears started. And secondly, in any event, it wasn't an abuse of process such as to mean that any concern should be given as to the fairness of the process that took place at the date of the possession order.
Yes.
And our final submission is effectively that in terms of the remedy that we need, and the remedy that Salix Homes need, they have the remedy they need. They have it, or they had it, in the 2017 order. That was the remedy they needed. They had the money judgment which they wanted for the arrears. They had the possession on the terms they wanted. They suspended it, which is what remedy they wanted. It's on that basis, my lord, that we say the appeal should be allowed. No merger, no abuse of process.
Yes. Any questions? Any questions?
No.
Thank you very much. Right, so that deals with the first
Yes.
part of the case. Obviously, if you lose on that, that's the end of the matter.
Yes.
If you win on that point, we then have to go on and consider the second issue, I think, which is delay.
Well, if we succeed on the question on the first ground, we don't need to consider delay, because one of our arguments in the court below was that not only were they wrong on the first ground, but if they weren't wrong, they were right, they were too slow in making the application.
That's the point of delay.
Oh, sorry, yes.
That's
Yes.
delay.
So if we lose on the first one, delay becomes relevant.
If you lose on the first
Yes.
one, delay becomes relevant.
Yes, yes.
Yes. Sorry, I mean that. Yes.
That's right.
So the point here is, even if you weren't entitled to bring the second action, Mr. Mantato is too late to challenge that.
Yes. And the simple point we make on that is that, firstly, of course, we accept the hearing which made the possession order in 2017 wasn't a trial, and that therefore
Not a trial for CPR purposes.
That's right, my lord, and therefore the CPR 39.3.
Not a trial for CPR 39.3. That's right.
But as we
That's
know,
applied by analogy.
yes, but we know that, as you say, by analogy, it is a relevant factor, and you've seen the citation there to Hackney and Finley, which of course I can take you to, and Lady Arden's judgment in that particular case of tab 9. In particular, paragraphs 23 to 25.
So which this is Lady this is Alden LJ in this one of the case.
This was Hackney Borough Council, London Borough Council, and Finley.
This is the Finley case. Yes. But you apply it more or less strictly according to the circumstances.
Yes.
And in her case, it wasn't so strictly applied, but elsewhere it has to be more strictly applied.
Yes.
And this is one of the cases where it would have to be more strictly applied.
Yes, and not least, of course, because there was actually execution of the order. She refers to paragraph 25 of her judgment. I appreciate, my lord, that there wasn't letting of the property, so it wasn't one of those situations where you couldn't allow Mr. Mantato necessarily back in because there was somebody there, but there had actually been execution of the order, and therefore that's a relevant factor when
That was
considering.
the 12th of September, I think,
That's right.
2017.
That was the eviction date. And what we had in terms of the applications, we had the first application.
The judge sets out, just so we don't go all this over again, can I just have a look at the judgment on this? Because the judge sets out at great length the submissions on this.
Yes,
And you were both the same counsel then.
yes.
So can we just see what he summarised the submission? You've got your skeleton argument, of course.
Yes, his decision on delay, page 71.
I know what his decision. I want to see whether he set out your arguments for you, because then you don't need to go over them over again on there.
You have the defendant's response at page 65.
Hold on, 1 minute. Just look at this. Right. He considers the evidence of the witnesses. He makes some findings of fact. Then on page 59 of the bundle, he sets out the submission of the parties as to the law.
Yes.
Then he deals, that's where he's dealing with the abusive process clause.
Yes.
That goes on for some time. And then we come on page 65 to the defendant's response.
Well, he has a page 63 our response.
Yours, right. So can I just, I mean, has he summarised your position
accurately on this?
Yes, I don't dispute that he set out submissions to be made in a fair manner.
I mean, so the question is, do you want to add to any of these points?
Well,
So can I just go through them one
Of
by
course.
one? And the first point he's got at the bottom of page 63. In terms of notice, the claim itself contains the date of the hearing,
yes.
as well as the post-hearing letter and subsequent letters. Not sure we've seen all of those. Then there were telephone calls between the parties, and clear from the purpose of delay that he was aware of the possession order and its suspended terms from June 2017.
Yes.
And the judge rejects that he only knew of the second possession order when he got the notice of eviction, so he rejects that. And then there's a 4-week one there. He says that unrepresented litigants get little assistance from this.
These are our submissions, of course.
No, I'm just because I want to make sure I understand more, because we don't need to go all over again then. And then he says there are 8 other reasons as to the reasons for theirs unconvincing. And then he goes through these. He says 10 months delay, doesn't matter to the solicitors. There's still 6 months unaccounted for, even if you didn't know about the second possession order. Can you just give me what's the 6 months from where to when?
There was a delay. We knew in September 2017 he'd been evicted, and although there had been the first application for oppression in January 2018, the application in respect of abuse of process merger.
The oppression would have been what? To set aside the warrant?
Yes,
Or to set aside the judgment?
set aside the warrant. There was also within that application, and you'll see it in the bundle, an application to, I think, let me just, if you don't mind, just check the exact wording, because you've got it at tabs 8 and 9. The one for oppression is at page 76 in tab 8.
Right, so setting aside a warrant
Yes,
and an order discharging or rescinded the order.
yes.
So what are we looking at there?
This is
Page
page
76.
76. This was the first application in January.
76.
So this is 3 months on from the eviction.
Right.
And my lord, in answer to your question as to what 6 months, that's the next tab, which is the application you see in respect of the abuse of process argument. That was made on the 19th of March. So in other words,
Which page is that?
this is at page 83. Should be tab 9.
No, it's in tab 7.
I'm
Let me
sorry.
just make a note of it. Let me just make a note of
And
it.
although that seeks the same relief as paragraph 2 of the first application, it's not an abuse process.
The one at page 83 is the abuse process, but the other one isn't. The other one is oppression on the basis of
No,
IP.
I mean the making of the second application seeking the same relief is not a.
Oh, I see.
Is not an abuse process.
It'd be a bold submission, I think.
I'm getting it inside. I lost it.
I never thought
Can we
of that
just start
argument.
page 76 is the first application.
Yes,
And it was made on the 31st of January.
yes,
And that is when order setting aside the warrant for eviction.
yes.
Where is the reference to oppression? So where is the reference to oppression? It's just a general application.
It's in the ground.
You'll see it page 78, my lord. You'll see just below the second heading, it says there's a paragraph that starts, a warrant can, however, be set aside if either the possession order is set aside or the tenant can show that the tenant has been obtained by fraud or there's been abuse of process or oppression in its execution, and it's the authority of Leicester.
Why isn't abusive process enough to cover this?
Well, the argument made in the first application was in respect of the fact that he had paid the arrears off on the day of eviction, and he said that because of what he was told on that day, there was oppression. In other words, oppression in many respects in those cases is situations which prevent somebody from exercising their right to apply to stay execution. And it was a...
Which is the passage you're referring to?
I was referring to page 78.
No, I know that.
Oh, sorry.
Where does it say that the abusive process is the fact he's paid it off?
It's the top, page 80.
I'm grateful, yes.
almost sounded as if you thought it was oppressive that he paid his debt
Yes.
on the basis that he would keep the flat.
Yes. Yes, I mean, that's right.
Paid the debt, and then it was oppressive that he wouldn't have paid it otherwise.
Well, in a way, he was effectively saying, well, look, I was told that if I paid this, I wouldn't be evicted, and I paid it, and I was evicted. So, but also, my lord, to be fair, it may have been said that, and that therefore meant that I didn't make an application to suspend the warrant because I thought that if I paid it, that would be enough. But he was obviously found not to be a reliable witness, and that application wasn't proceeded with. In respect of tab 9, this was the one which was more directly to do with abuse of process and merger.
Page 83.
That's right, my lord.
Page 80. And that, so let's just see, where's the grounds there?
You can see at the bottom, well, first of all, 86, you can see in the numbered 1 to 9 issues of delay raised in the application, the explanation for delay. You can see at the bottom of that page, page 86, there's the start of an explanation as to merger. In other words, that the possession order of 2008 has not expired. And you can see in terms of a wider abuse argument, my lord, on page 87, there's a paragraph in the middle that starts yet further, which is submitted.
All right, that's fine. So that's what it is. So let's just go back to the judge's reasoning again. So you think the 10 months delay is what, from September to March?
There was a 10-month delay from the possession order.
What date was that?
The possession order was made on the 9th of June 2017.
So that's from June to...
But the claim was issued the previous month, so I suspect it must have been the claim issue that was being referred to. In other words,
This is your submission still.
yes.
This is not.
Oh, it's not the judge making
No.
a
That's what I'm
finding.
trying to understand.
The,
Yes.
I mean, the judge
Yeah.
does say at 71, he talks about a delay of 9 months.
And it will be 9 months from the date of the possession order.
Yeah. And he says he's considered your forceful arguments and accepts your comments with regard to communications. I'm not quite sure what those are.
I think those are the references to the dates that my lord read out and said, well, we don't have those letters. That was the normal correspondence that takes place between social landlords.
Have we got them in the bundles?
We don't have them in these bundles, no.
Is
No.
is that what the judge is referring to towards the bottom of 63, top of 64? Those are the comments?
That's right. I think those are the letters.
So, do we take it that he found, as a fact, what is said in the paragraph towards the bottom of the page, beginning in terms of notice,
So
Yeah.
which page are we on now?
63,
Bottom.
last complete paragraph on the page, in terms of notice, that paragraph,
Yes.
and then there were also the post-order telephone calls, that paragraph.
Yes.
So when he
Where
says,
was that? What was the evidence on that in the form of witness statements?
There was witness statement evidence from officers of Salix, both in terms
Do
of
we
the
have
sending of the
do we
letters.
have those?
Sorry,
Do we have the witness
you
statements?
don't. No.
right, so the district judge is accepting what he calls your comments with regard to communications, and that's those two paragraphs.
That's right. Although he then goes on, of course, at page 71, rather confusingly, having done that, my lord, and you mentioned the sentence halfway down in the paragraph that starts, I now turn to the issue of delay.
That's right.
He says on the second sentence, I have carefully considered blah, blah, blah. I accept his comments with regard to the communications at the very latest by the end of August. So, having said I accept what's been said in relation to the correspondence from June and the phone calls that have been made, certainly by August, Mr. Mantato was aware of how precarious his situation was. I mean, in essence, my lord, our position on this is that, of course, there was delay. On any analysis, that there was delay. That doesn't necessarily get us home, of course, both because 39.3 isn't directly applicable, but also because there are other factors to consider. But it is an important factor, and it's an important factor particularly because of the fact that the application was made after the eviction.
I mean, one of the criteria in 39.3.5, even if it's applied by analogy, is whether the defendant had a good reason for not being at the hearing. Was
Yeah.
any reason? I mean, I can't see the district judge looks at any reason for Mr. Mantato not being at the hearing. Was any good reason suggested?
Well, certainly no finding on that. Mr. Mantato, I think, and my learned friend will correct me if I'm wrong, I think was saying that he was a very busy person being a van driver and he didn't necessarily see the correspondence because somebody else was also staying with him at the property, I think, was the evidence. And that therefore he didn't remember seeing the correspondence. There was no.
I mean, the district judge doesn't find that he had a good reason.
Well, that's right. That's right.
Was the point argued in front of him?
Well, it was argued in the sense of, firstly, you have to look at 39.3, and then one goes through the 39.3 subpara 5 requirements, and incidentally, this is in the bundle, authority bundle at page 271. You can see that did he act promptly when he found out the court had exercised its power?
Yeah, but I'm trying to see what was before the judge says there are two issues.
Yes.
He says one is stopped with two delay. He doesn't say there was any other issue before him that was raised.
The only issues before him were the oppression argument, which of course is not before you today, and the question of merger stroke res judicata stroke abuse of process, which involved the question of delay.
Well, the judge sets out between the top of page 65 and halfway down 69, he sets out very extensively the arguments that Mr. Stark had advanced.
Yes.
And in the end, it seemed to me, when reading it, his decision was, well, the fundamental point as to the second action, almost as if delay was irrelevant, because he was saying that it's so fundamental a point we don't really...
The way I would characterise it is saying that because of his finding on the question of merger, and because of his finding that that second action should never have taken place, it couldn't possibly be the case that some procedural argument would overcome.
Yeah, but how does this work? I mean, I'm trying to think if we were with you, the question then is what should we say or do? Of course we can make a decision if we're with you, we will, saying that your appeal succeeds on the ground that the judge was wrong so far as he went on the question of merger. But what then happens? Do we then leave it to the parties to go back to the judge to decide whether in the exercise of his or her discretion the defendant here should not be entitled to apply to set aside the order? or do we do it? I mean, I'm just slightly... On the one hand, we don't want to waste your time and cost and everything else. On the other hand, we've got to be very careful that we've got all the right facts before us. So what do you want us to do?
Well, look, if you feel that obviously you don't have the right information, then you, as you quite rightly say,
One might take the view that if Mr. Stark wanted to uphold the judge's order on different grounds, that a respondent's notice might have been put in explaining what reason Mr. Mantato had for not attending the hearing and why he had not delayed.
I mean, absolutely, my lord. I mean, our primary submission really is that his argument, the judge's conclusion, which was that effectively whatever the situation with 39.3 and whatever the question of delay, which ordinarily would prevent any set aside of the judgment in any event, it wouldn't make any difference because of the importance of his decision in respect of merger. And that's effectively his decision. That's what he's saying. That we can
I know that. If we're with you, then that's not the end of the.
Now,
it's not the end of the matter.
If he's wrong on that, what we say is that we say he's wrong on that, and we say that it's clear evidence of delay. You don't need any further evidence in terms of the letters that you referred to, my lord, because not only because he refers to them at page 71, and he refers to acknowledging the evidence that I talked about in my final submissions, but also because the delay is obvious. The delay is obvious under whatever analysis, Regency roles or whatever case one takes. It's obvious.
Well, maybe on this point we should hear Mr. Stark, see what he can respond. So, my Lord's raised a very important point, which is, you may say this is technical, but if you wish to uphold the decision of the judge on some other ground, it really needs a respondent's notice raising the issue of what should be done on delay.
Well, in relation to the question of delay, of course, the judge found his approach was this was a special Forcelux and Binney-like case. If you recall in Forcelux and Binney, that was the case of the gentleman who had his lease forfeited for £1,000 or so arrears, and that was where the court after a first hearing. That wasn't a trial. Therefore, section CPR 39.3.5 did not apply in its rigour. And the relevant rule is CPR 3.1.2.5, which is the wide case management power of the court, and allowing the setting aside of a order made in a first hearing fell within that power. Now, what my learned friend said in those circumstances was that you then applied Hackney and Findlay to that case, where Lady Justice Irwin had said that in a standard rent possession case brought by a local authority, then by analogy, highly relevant factors were the three criteria.
Yes.
But in Salix itself, there was a specific finding that he hadn't acted properly. So one of those criteria wasn't met. And they said that what was different was that that was the exercise of a discretion by the district judge. And we say that that's exactly what the district judge did here. Because this was a CPR 3.1.2.5 case, he had a discretion. What my learned friend has to therefore attack is that he either completely misdirected himself, or he proceeded on the wrong principles, or he reached a decision applying the right principles that no reasonable district judge could
I think what we're saying is if we read the judgment, he really said, at almost express terms, I don't need to deal with the issue today because there's a substantive rule of law which bars you. That's where it ends up.
Well, the way I say that he applies the Salix test, if you look at what he says at the third paragraph down on page 71.
Yeah, he says 39.3 is not applicable.
Yes,
He
and he says
applies 3.1.2f.
Yeah.
But if we were to take the view that, consistently with Hackney and Findlay, 39.3.5 ought to be applied by analogy with whatever appropriate adaptations there are, you don't put forward an argument for saying that the criteria in 39.35 have been complied with, and in particular you don't say that Mr. Mantato had a good reason for not being at the hearing.
Well, if the court was of the view that the learned district judge was erroneous in the exercise of his discretion, he proceeded on the Salix basis. What's also can be seen, he didn't take into account points that were made about the delay positively. Positive points made about the delay that were made in support of his case.
What were they? Because if you look at the judgment, page 65, he says expressly that you did not address delay in your opening skeleton. Now, had there been a statement or a witness statement upon which bore a delay, you would have been obliged to do that. You were facing a situation where you might have lost on merger, but you still had other abuse of process arguments, so the position would be less stark. So he says nothing in the skeleton, there can't have been anything in the witness statement from your client, and he then gives pages of reference to your oral submissions without mentioning anything positive on delay.
Well, evidence was put in the application at page 86. Part of the evidence providing support of the application, setting out various factors as to why there was delay, such as that he was not eligible for legal aid, that he'd sought some advice and contacted the claimant and asked them to readmit, couldn't take them out further, sought advice from his MP, he was unaware further legal action could be taken, then obtained advice following the issue of the injunction proceedings, that he'd been homeless throughout the period and suffering from ill health issues, seemed to be instructed in correspondence with the claimant's solicitors in hope of avoiding the litigation, and only upon receiving advice from counsel after we saw the confirmation that the order had not merely, that there'd been a previous order, which we weren't aware of until February, then we made the application, and there was a short delay because there was a misunderstanding as to whether or not a written opinion was required. But we were clear on that occasion, on the 6th, as soon as we saw it, we told the claimant that we were proposing to make the application, and District Judge Moss listed the hearing in May on the basis that such an application was going to be made. It was canvassed before him at the directions hearing. So the district judge doesn't deal with issues such as that he was homeless during the period, which may well be significantly regarded in a balancing exercise in relation to delay, considering all the circumstances of the case under 3.1.25, relevant. So my submission would be, for the reasons very much that my lord has indicated already, is that if you were of the view that he'd gone wrong in relation to that, then it should be remitted, so that he considers all the circumstances in accordance with the test that's appropriate, rather than this court being in a situation when it has only half the picture, doesn't have the witness statements. That would be the safe and proper course.
Was there ever a witness statement incorporating what's said on page 86 or anything like that?
Yes, I understand it was in Mr. Mantato's witness statement, as I recall, I'm reminded of that.
My Lord, can I just interrupt, just to say that there is in the judgment at page 54, in a reference to Mr. Mantato's evidence by the Deputy District Judge, in his last paragraph on page 54, you'll see...
He gave oral evidence.
Yes, he was there and he gave oral evidence. He denied, you can see from the third sentence, sorry, he denied seeing the claim form in relation to the proceedings and receiving the letters dated the 12th of June, informing him of the terms of the possession order, 22nd of June, informing him of the impending eviction, etc., etc. And you'll notice also, my Lord, and this is what I mentioned briefly, I think, in my skeleton argument at the top of page 55, in fact, the second paragraph, that starts off in terms of the quality of the evidence of the defendant who gave live evidence.
The most we've got from the judge, the findings are that he accepts, he accepts that, and this is page 71, at the very latest, by the end of August 2017, the defendant would or should have been aware of the precarious situation in which he found himself. So that's the finding of fact.
Yes.
And that relates to the arguments about communications. And similarly, at the top of page 64, the finding of fact that he doesn't accept Mr. Mantato's statement that he only knew the second possession when he got notice of eviction. So that's one finding of fact of the judge. He would or should have been aware of the precarious situation by the end of August 2017. But there's no other finding of fact.
No.
That's the only one. What we'll have to think about is we'll carry on at 2 o'clock. I mean, obviously, if we can deal with this, if it comes to the situation we have to deal with this, it's far preferable that we do deal with this now if we possibly can, because it means less expense, less time, and everything else, of course. But we have to be fair to everybody. So we'll resume again at 2:05.